Cape Town. It gives me great pleasure indeed. Gives me great pleasure indeed. Can you hear me now, Corin?
We can.
Thank you. It gives me great pleasure indeed, a huge amount of great pleasure to welcome to us this afternoon Clayton Hall. Clayton Hall is known to many of us as NatMed's head of legal and sales and has extensive experience as a medical malpractice defense attorney. And that's because he is indeed an attorney. He's also a consultant to the insurance and healthcare industries. There in front of us, we have Clayton Hall. He's going to come back in 2 weeks from now, ladies and gentlemen, because we're having our final webinar in 2 weeks' time, not next week, the following week. And he's going to be there as part of this Time to Professors faculty. Talking about next week, we have Daniel Kidd with us, mitigating risks and challenges of stand-in doctors. Our sponsor this week is indeed NatMed, and I'd like to thank Stephen Kellerman very much indeed for being so generous in sponsorship. And I spent the weekend with Stephen up in Joburg, and we had a great time. So, ladies and gentlemen, we're getting towards the end of season 4, episode 29. So this is about the 4th year and the 29th episode. It's been wonderful having you as part of our team. And a great thank you then to Clayton Hall and also to Corin. Thank you very much indeed. I'm joined, as you can see, by Steve. Steve, would you just put your head in there?
Yes, and thanks very much. And it's wonderful to have a medical legal talk. Yeah, we're looking forward to tonight. So thanks for agreeing to do the talk.
Don't forget to join the newsletter if you've not already done so by checking the chat box in Zoom. And the link is going to be loaded over there. Anyone who's already subscribed to the newsletter, what? Anybody's already subscribed to the newsletter, please complete the survey so we can make 2024 webinars even better. So without further waste of time, Clayton, and your talk is medical malpractice and the medico-legal implications. Thank you very much indeed.
Thank you so much for the very warm welcome, and yeah, very pleased to be here this evening to chat with you all about these important topics. I think this can be an area that can be quite boring or dry, so feel free to ask questions or spice it up along the way. I'll try to provide some examples and things just to make it also a little bit more real. But bear with me. There are some exciting bits. Be that as it may, I think it's an important topic to consider. We tend to react when receiving the results of either medical malpractice or perceived medical malpractice, where patients have complaints, etc. And it's only at that stage that we ever really confront it or consider it. And so tonight's talk is really an attempt to just if you're not already aware, to talk a little bit about negligence or medical malpractice and really what's the difference between medical malpractice, medical negligence, medical mishaps, and then what are the typical consequences when something happens? What can you expect to receive, and what to do when you do?
Yeah.
As was mentioned, I'm the head of legal at NatMed and of sales. I practiced as a medical malpractice defense attorney, specializing in neonatal cases with Weber Wenzel for a good few years. And now with NatMed, we're insurance brokers who've been specializing in medical malpractice insurance since 2000. Have one of the most extensive kind of claims databases in South Africa, and really understand kind of what's going on in the claims space and directly affecting practitioners like you. So let's get into what are we talking about when we talk about medical malpractice. So it's the sort of colloquial or general term that's used to describe negligence on the part of a healthcare practitioner. Or it could be, representatives of a healthcare facility like nurses or other employees of the hospital. And negligence can be either an act or an omission to act, which causes harm to another. So either injury or death. But not all medical errors are considered medical malpractice, right? So all negligence is, whether the negligent act or omission is on the spectrum of negligence from kind of really intentional or reckless, which we would call gross negligence, or just ordinary negligence. But there are medical errors that are just not considered to be negligent, and so that's where we really differentiate between medical error and medical malpractice. It really includes a range of negligent acts. We'll talk a little bit more about them later, so I won't go through them here. But there are a number of ways to be negligent, and we have seen very many. A little bit around negligence itself. So what is the test to decide whether or not there has been negligence? How do you differentiate between a medical error or a mishap and one that is considered to have been negligent? So the test is really what would the reasonable person have done in the same circumstances, and did you in fact do that? So normally it's done in the negative, like the reasonable person would have foreseen the possibility of harm and would have acted in this particular way. You did not act in that way, and therefore your behavior is considered negligent, and you should be held liable for that. For practitioners, of course, it's more the reasonable practitioner test. And why that's important to differentiate is because it's not just considered the reasonable person in specifically your circumstances, but there's a standard that you would be held to. And it's not the standard of the absolute best in the profession, right? So a medical practitioner, there's a case there, Mitchell versus Dixon, 1914. Medical practitioner is not expected to bring to bear upon the case entrusted to him the highest possible degree of professional skill and care. They're bound to employ reasonable skill and care and are liable for the consequences if you don't. And in Van Beek versus Lewis, 1924, this was reinforced. It's the general level of skill and diligence possessed and exercised at the time by the members of the branch of profession to which the practitioner belongs. And so identifying which reasonable practitioner you need to test the actions or behavior against, these two cases are instructive in really positioning that in the spectrum of skills and capabilities.
So, Clayton, what is the sort of Bolam principle that they sort of use? Is that the Bolam principle that we often talk about?
And secondly, has it been superseded? I understood that there have been recent regulations which may have made it slightly stricter for us guys.
Are you talking the Montgomery?
Yes, the Montgomery.
Yeah.
From it's a UK, the Crown versus Sheffield Health Authority, related to the Montgomery incidents.
Right, so those cases are not binding on South Africa. They're instructive, and so I think it's a warning sign or a warning for the industry here to make sure, because of course our judiciary also will be very well aware of all of those cases, but not a principle that is ingrained in South African law yet. I think
that's very encouraging.
Yeah,
it's very encouraging because I was reading around this for something we did last week actually, and I was under the impression that we were very close to being judged according to what had happened at the Montgomery ruling. So it's encouraging to know that you're still stuck, not stuck, but still held more to the as you said, the Van Beek and Lewis etc.
Yeah, I'll double check on it to make sure that I'm not telling you mistruths, but that is the impression that I have, and
No,
I'll
we'll
make
be
sure
very happy to. Yeah.
that's correct.
No, we'll be very happy to be held with a less strict one of the, more like the Boland principle.
Yeah. Thanks,
So,
Clayton.
pleasure, and thanks for the question. Let me talk a little bit about some of the kind of concepts around negligence. You may have heard some of these terms, but let's explain them a little bit. So when we talk about the test for negligence, it's really the standard that you need to be held against in order to determine whether or not someone in your circumstances who has the kind of average level of skill for the profession would have foreseen the harm, acted differently. What would they have done? Would that have resulted in a different consequence? If the reasonable person or reasonable practitioner would have acted differently, but in acting differently, the consequence or the end outcome would have been exactly the same, then you may still be negligent, but the damages would be where there would be a difference in that you actually haven't caused any harm additional to what would have been suffered, if you had behaved in a way that would be considered not negligent. When we talk a little bit about the standard of care, so there's a difference here between a negligence and a complication, right? And so complications arise, we all know that. Practice of medicine is not an exact science, risks materialize, and there are a host of risks. The question is, what would a reasonable practitioner in similar circumstances have done? And here, when we look at what the standard of care actually is, there's an instructive comment from the courts, which says that provided a medical practitioner acts in accordance with a reasonable and respectable body of medical opinions, his conduct cannot be condemned as negligent merely because another equally reasonable and respectable body of medical opinion would have acted differently. And this really provides for where there are differences in opinion or where there are different approaches, and there isn't a definitive answer as to which is absolutely the best, as long as where the kind of treatment paths or views are opposed, as long as the treatment is based on something that is logically sound, the court can't choose that it prefers one path over the other and make the other one negligent. You have to accept both, provided there's a sufficient body of evidence to say that it is appropriate. And of course, the standard is different for different specialists because you have different training, you have different experience, you have different kinds of scenarios and different patients that you encounter. And so, of course, it has to be contextual for the type of specialist. You may have also heard of degrees of negligence. Here we can talk about, ordinary negligence, gross negligence, remote negligence. These things make no difference for liability. So to determine whether or not you should be held liable for your actions, and by held liable, it means, usually it means liable to compensate somebody who's been harmed. It doesn't make any difference what the degree of negligence is. These are not concepts that matter for the courts. Where it may make a difference is in the amount of the award or the settlement. So, if you've been grossly negligent, the court may look on that less favorably and award a higher amount to the plaintiff. Even though we don't in South African law have the concept of punitive damages. So the courts can't punish you by making an award that is unreasonable, like they do often in the US to make a point. Here we don't have that ability, so it has to be within the reasonable bounds of what would be expected, and then also logically sound when calculating the damages. There is a concept called gross avoidable negligence, which is not really a legal concept, but it's one that's been incorporated into some medical malpractice insurance to say, we will not indemnify you if the negligence was gross avoidable negligence. And gross avoidable in this context, they mean it's so obvious and so reckless that doing it is tantamount to intentionally causing harm. And so you shouldn't be able to enjoy the benefits of insurance for acts like that.
Can I ask you a question? How does the court deal with sort of profound differences in expert opinion? When they bring two you've got the two sides that are differing quite profoundly in terms of the opinion,
Yeah.
in terms of what might be reasonable standard of care. And it's, it's sometimes it can be difficult. What do they do in those circumstances? Does it default to the one side?
It's a very good question. So, the judges of the judiciary have the right to have a medical advisor with them. So somebody who will actually understand the medical content and be able to provide an opinion on the medico-legal opinions also that are received, including expert opinions. What the responsibility of the legal team is to ensure that they are not falling into the trap of seeing the expert reports holding practitioners to a standard that is at the level of the expert, as opposed to at the level of the reasonable practitioner with the usual level of kind of skill and diligence that is held by the profession. And so there is definitely a tendency for some of the more critical medical legal experts to really be holding people to a standard that is quite high in their reports. And it's the duty of the legal team to point that out and to say, our expert should be relied on more than that one for these reasons, and try to convince the court that it's a more measured response. But really, it's up to the legal teams to convince the court one way or the other. And there are a host of ways to do that. So one of them, as I mentioned, is attacking the kind of level of skill and diligence that the expert is holding that practitioner to. There are also, pointing out in the reports where, and what often happens is when experts are trying to be, they're really trying to find all the possible things that went wrong. They could be overly critical of many elements of the care that are simply not causative whatsoever, and going almost a little bit outside of the bounds of commenting on those things. And again, it's up to the legal teams to say, those comments are not relevant. We should focus only on that which actually determines liability here, and try to limit the way that is perceived. I hope that answers the question.
Yeah.
Thank you.
Great. A little word on contributory negligence. So one can't avoid liability by being kind of the least negligent of the bunch, right? I'm sure that you will have seen there are summonses. Sometimes the hospital receives a summons, and it's purely because the legal practitioners don't understand that the hospitals don't employ doctors. They get that completely wrong. Sometimes it looks more like an invitation to a street party where they've sued absolutely everybody, including the employees of the hospital and every practitioner who came anywhere near the patient. But if there was negligence and your negligence contributed to the harm, then you will be liable jointly and severally, which with the rest of the defendants that are also found liable. And jointly and severally just means that the plaintiff has the right to claim the entire amount that they're claiming from you, even if you're 1%, 1% negligent, without having to claim from the other defendants. And then it would be up to you to seek the rest of the funds from the other defendants. Typically, they go after the people with the deepest pockets or the best insurance. An example here with the contributory negligence. So it's not only multiple practitioners or even potentially healthcare facilities and practitioners all being partly liable, but also patients can contribute to their own negligence. So an example where there wasn't considered no contributory negligence, a patient got Volkmann's ischemia from a tight cast. And didn't, just the leg went, I think it was either his leg or his arm went quite blue, got cold, and, had serious issues. But the court held it was not the patient's fault because he wasn't actually told to come back to the practitioner or to a hospital if he noticed any of these symptoms. And so that is quite an old case. More recently, we have quite a few cases where if an individual notices that they are suffering from symptoms, those symptoms may have even been called out specifically in the post-operative care by a practitioner, they delay in returning to the hospital or coming to casualty. By the time they do, they're in a far worse position than they would have been had they come in when they should have. And those delays often are considered to contribute to the eventual outcome. And a percentage of the award can be attributed actually directly to the plaintiff themselves. So they effectively end up taking a discount on any award that is given to them.
Clayton, hello, on that point of patient's negligence, I'm doing two cases. The one is a woman that was advised to come back when she had abnormally heavy bleeding, and she did not come back, and she had a prescription of a pill prescribed over the phone. She still didn't come back, but yet she got a pulmonary embolism. Now, the suit then arrives from her lawyer saying that how can you be so negligent as to prescribe a pill, and now she gets a pulmonary embolism. Is that an example of patient's negligence? As in a second example that I'm doing, where a woman is advised to have a Caesar, she's against it, she has a grossly difficult delivery, the baby's damaged, and despite the practitioner strongly advising and pleading for her to have a Caesar, she refuses. Are those examples of patient's negligence?
So I think neither of them actually are. The second, I'll deal with the second example first. The second one is actually just an example of patient autonomy in practice, even if it's against doctors' wishes. In situations like that, what's extremely important is documenting the advice and documenting the refusal, even in the face of a detailed explanation of the consequences of making that choice. And where the patient has exercised their own autonomy and it's against practitioners' sound advice, and it's been recorded and the consequences were illustrated, then the materialization of those consequences can only be laid at the feet of the patient. And so I would say that there is no contribution of negligence from the practitioner in that situation. There is only the harm caused by the patient's decision. Only by the patient's decision. So,
let's hope the court sees
there should be no liability on the part of the practitioner in a circumstance.
Okay,
like that.
Thanks, Clayton.
No problem. In the first case, it could be, however, the pulmonary embolism. The question there becomes more around causation, right? So if the patient had come in, could something have been done? And if that thing was done, would the pulmonary embolism have arisen? If you can say, actually, if they'd come in at that time, then they would have it would have been picked up, or there could have been some intervention and it would be prevented. But if it's not preventable and it's not foreseeable, then nothing that happened in between was going to change the eventual outcome, and the pulmonary embolism would have happened regardless. And so there's no contribution of negligence there. It's just it's considered an unforeseeable event that you can't prevent. So there's no negligence for anyone in a situation like that.
Thank you, Clayton.
Pleasure. Where, for instance, a patient who is post surgery, let's say they've been advised if there is pinkness or redness around the wound, or it opens, or a stitch comes out, or they notice any pus or whatever, that they must come straight back to the practice or go to a casualty department. Instead, they choose not to tell the practitioner, and they go and see a wound care someone or other who may or may not be good at that, locally, because they want to take care of it themselves first. They try that for a week or so. Eventually, they end up with severe sepsis. They end up at a casualty department, and and they're being treated there. If there was negligence on the part of the practitioner in the first case that that somehow contributed to the sepsis, then the patient's delay and choice to go to see a wound care sister instead of coming back to the practitioner, that would be contributory negligence. Of course, if there was no negligence on the part of the practitioner in the first place, then that negligence is all on the patient.
Right.
And then a little on medical mishaps. So the courts do accept that practitioners are human and make mistakes. This is particularly in the case, where we look at complications, right? So where there are recognized complications, it's not always possible to not cause harm, no matter how hard you try. Sometimes you're going to nick a ureter. Sometimes you're going to, perforate the bowel. It's going to happen. If the patient is aware that it's going to happen or could happen, what the consequences of it are, they've accepted those risks, it happens, and you're doing the usual to establish, that there aren't any perforations before you close. We know that at least sort of 15% of those cases don't get identified until some days later. They don't get identified intraoperatively. But there's no negligence in a case like that if it's been properly detailed to the patient, they've accepted the risk, and you weren't being reckless when you caused the perforation. In a situation like that, it's simply considered a medical mishap or a complication, and there will be no fault and no negligence on your part. But where there are errors, the error has to be reasonable, and an error in judgment can still result in liability for damages. So even if, let's say, you exercised a particular procedure, the procedure was flawless, everything went well, but it was the wrong procedure to perform for the patient's symptoms, you can still be held liable for something like that, because that's an error in judgment, even though in practice the procedure went well. And it's kind of summed up in this statement from 1954. So we'd be doing a disservice to the community at large if we were to impose liability on hospitals and doctors for everything that happens to go wrong. Doctors would be led to think more of their own safety than of the good of their patients, and initiative would be stifled, confidence shaken. Proper sense of proportion requires us to have regard to the conditions in which hospitals and doctors actually have to work. We must insist on due care for the patient at every point, but we mustn't condemn as negligence that which is only a misadventure. So one of the best ways to shift things from perceived negligence to a misadventure is with proper informed consent.
So Clayton, just one last thing about all this. Where do the courts and where does the law actually see the experience level of the doctor who's being sued, and how does that actually get gauged, or is that also just an opinion? What is the sort of legal opinion on that?
Well, because the practitioner has to be judged against the level of care and skill of the kind of average practitioner in that specialty, that's the level that they will use to test. So even if you do have way more experience, the court can't say, well, the reasonable expert with all of your experience would have done X, Y, and Z. They would typically, say, okay, well, what you did, would the reasonable practitioner have done it? If there is evidence that because of your expertise, you actually did know, or you ought to have known because you've done them 1,000 times, then there could be a different view. But it's whether or not the experience matters in establishing the negligence. It won't always be taken into account, but sometimes it could be a relevant factor in trying to establish whether or not there was negligence.
Okay, thank you.
A few examples. So misdiagnosis or missing diagnoses, improper medication or dosage, poor follow-ups, poor post-op care, lack of post-op care, not seeing patients before discharge and doing proper examinations before discharge, where complications arise and informed consent has not properly been taken, misreading and ignoring test results, failure to take informed consent, and surgical errors and wrong site surgery. This, I must say, I had a practitioner that I spoke to about an incident that occurred where he operated on a patient's finger, but he operated on the wrong finger. Now, it's a tiny operation, very small. It was really just pinning the finger. But it took them a week to realize that the pin was in the wrong finger, and then to take it out and put it into the correct finger. And just 3 weeks after speaking to this practitioner, he called me again and said, I had a patient who was marked to have their right knee operated on. When I got them into theatre, I thought the left knee looked way worse, so I operated on that one instead. And so, this unfortunately wrong side surgery is still happening quite a bit. And sometimes the same practitioner, we need to make sure that they've got a left and right tattooed on them going forward.
Is that insured by NPS?
Maybe not with us. So the other thing we're seeing a bit more of is also test results. So, if you have ordered a test and the results of the test are relevant to the next action you take with the patient, please check the test before you take the next action with the patient. We've had some very sad cases recently that have resulted from this. Pregnancies happening because of results showing that fallopian tubes are not fully transected. There's miscarriages from pregnancy test results not being checked before proceeding with a procedure that naturally would have a high chance of inducing a miscarriage if performed while pregnant. So and also not just ectopic pregnancies, but also proper full-on people having new children that they didn't want, from failure to inform patients about the results, the histology results from post-sterilization. I'd like to ask the group to help me with this next one. So, what actually comes next? Once there's been medical negligence, what happens next? What are the consequences? And this is where we get from kind of medical negligence or medical malpractice into the medico-legal implications. So where the law comes to assist patients, or to make sure that the practice of medicine as a whole, is being practiced responsibly. We tend to get one of these 6 things happening. By annotation, so if you look at the little Zoom bar, you may all be familiar with it. If you're not, just take a look. There is a button called mute. There's a stop video, participants. Along that bar, you should also see a little pen symbol that says annotate. If you click on that and click on stamp, and then choose whichever stamp you like, star, a heart, a question mark, whatever's there, and then just click it onto the screen, and I'll give an example just so that it's done. It'll place a symbol just within one of these blocks. If you could, if you are able to find the annotate, could you put an annotation into each box for as many of these as you have ever received?
It could also be showing as a sort of pencil in the corner, just like a little green pencil in the corner if anyone doesn't have the actual screen size for the annotate button, just in case.
Right, and so I'll give a minute or so for everyone to figure that one out and to put this here. So if you've received 3 requests for records ever, put 3 little symbols into the request for records bucket.
And Cameron, you're going to tell us what to do when these things come, are you?
Yes.
Okay.
Well, I'll describe a little bit about what each one means, and what the typical consequences and course of action that happens straight after that. Yeah, drawing if you need to, that's all fine. I'm going to just hide the names of annotators as well, so that you can feel free to place it there without.
Yeah, I've had all of the above.
Okay, it seems like people might be struggling to find the annotates. So
yeah, I think so.
I'll keep talking about these in the meantime while that's happening.
Do you want me to just launch a poll?
Yeah, if you've got it ready. Let's
Cool.
go for it. I'll just clear the drawings. There we go.
Yeah, that's easy, I think. Corin, how do we annotate those? It doesn't work for us.
What is it giving you an error?
No, we just touch. Steve touches and nothing happens. Do we just touch on the screen, or do you have to click with
the hosts and panelists can't vote, so it's it's keeping you honest.
All right.
Okay, well, we don't have anything like that anyway, so.
Are you getting results there, Corin?
Yeah, we've got about 49% of people participating. I will share the poll. I'm going to give it another 20 seconds or so, and then I'll share the results.
Thank you.
Thanks.
Well, while we're waiting in that 20 seconds, if I can ask Cameron, why don't they use more assessors? Because in the olden days, they had these old doctors that sit next to the judge, one on the left, one on the right, and that helped him. Because I spent a week last week in the High Court, and I can tell you the judge had no idea of what we were talking about. And I thought, had there been assessors, they would have in an instant come to his assistance. Why don't they do more of that?
That is supposed to be still the norm. I cannot think of any reason other than poor preparation, or I don't want to be disparaging of the judiciary, but yeah, I don't know. Sometimes the judge will just decide that they don't need it, and that they'd rather
Hang
go
on.
without.
Okay.
But it's it's something that should be insisted upon, because without that kind of knowledge, it's extremely difficult to understand a lot of the technical things that happen in medicine. And I think that judges should all absolutely be required to have a system with it.
Thank you, Cameron. Well, there you've got your poll results.
So yes, it looks like no one's voted for a summons, which is good. It means this is a nice, safe group. We've got a couple of letters of demands, inquests. Everyone seems to be, there's a lot of familiarity with HPCSA inquiries, requests for records, and plenty of complaints. So I think everybody has seen that, and you will see from the way that that's structured, it's kind of it's almost like a funnel. Very high on the side of the complaints, very low on the side of the letters of demand and summonses, which is good. That's what you want. That's definitely what you want to see. It's because this is often an escalation that happens from left to right. So I just want to clear the drawings. There we go. So often it'll start with a complaint, someone bringing something to you, or either they're just verbally complaining, or you receive an actual written complaint, and they're expecting something to happen at that point. They want to be communicated with. They want to be told that they're right. They want to be potentially given compensation at that stage. Some do, some don't. Some just want to have their bills written off. Sometimes complaints are not motivated by something you've done. Sometimes they're motivated by the fact that the patient just doesn't want to pay for something. But they all obviously have to be dealt with. Requests for records can be completely innocuous, from a patient just asking for their own records because they're going to a different practitioner, or they're moving, or for some reason. Or they can be sent to you by the family members of a patient, which often happens. Mothers in particular like to request records on behalf of their children. And lawyers, of course. When you receive it from a lawyer, then it's a sure sign that something's going on. Sometimes we receive these because they need your records in a case against someone else, some other practitioner, and then it's obviously a lot less scary. But if you are insured, which you should be, every single request for records, no matter how innocuous, must be reported to your insurers.
And do you give them the records or not? Do you just say, hang on, I'm going to speak to Clayton, and you speak to Clayton, or should you just send them and then what do you do? Respond or not respond?
Speak to Clayton is always the best path, but the rules, to put it in as simple terms as possible, if a patient requests their own records directly, you can provide them with copies of those records, or you can provide them with an extract from the records or with a report. It depends on what they've asked for. If they want the actual records, it's best just to provide a copy of the records. The records don't belong to the patient, but the information is theirs, and so they have a right to access the information. But the records themselves actually belong to you, so you keep the originals. If it is ever from an attorney or anyone else, then always check with your medical malpractice insurer to make sure that they can check that all of the required forms, the PIA applications, the ID, everything are included with that. Because if you provide the records without ensuring that all the formalities are in place, then you can actually be, liable for breach of confidentiality, for sharing records in a situation where it isn't proper to do so. And so it's always best to have a double check that all the I's are dotted and T's are crossed. But if it's an individual patient and they're asking for it themselves, then you can go ahead and provide them. If it is a family member, like a mother saying, I want this on behalf of my child, unless that child is under 12, the answer is no. The patient needs to consent to that themselves. And then you would want to see a written consent signed before, and authorizing whoever's actually asked you for the records to receive them, in which case then you can release them. But always better to just have your insurers or brokers sort that out for you. HPCSA inquiries. So, there's usually often a progression. If the complaint's not satisfied, they'll ask for copies of their records. They'll take those copies of the records, write out their complaint, and take it to the HPCSA. There are so many cases that we see at the HPCSA at the moment for absolutely ridiculous things. And often that ridiculousness is borne out by the patient's complaints not being addressed, or them not feeling like they've been heard adequately at the time of making the complaint. So it's important to have a proper complaints process in place and to deal with complaints in the right way, because you stem the kind of flow along the continuum towards summonses and letters of demand. Inquests naturally are, it's only when there are deaths, so it's not always a consequence, but that does occur, and then lawyers are always involved. Up to the point of HPCSA inquiries, you can get away with not necessarily involving lawyers. Once you get to a kind of an inquest or a serious HPCSA inquiry, letters of demand, summonses, you're always going to need lawyers to be involved to assist you with that, because there are legal formalities to take care of. For the letters of demand, as soon as you receive something like that, you absolutely have to notify your insurers. They should be the ones who tell you how to respond to it. Even no matter how ridiculous the demand is, it's better to not respond to the letter of demand and let them appoint attorneys, or to respond on your behalf, or assist you with what to do. And then, of course, what you really don't want to happen is to receive summonses where now legal action has actually been instituted. Up to the point of summons, between letters of demand and summons, prescription is still running. And prescription, for those of you who aren't aware, is the period within which you have the right to make a claim following an event that causes harm, and your awareness of the harm that's been caused, or that some harm has been caused. And so this usually runs for three years. In very simple cases, an adult has surgery, there's a complication, they're aware of the complication, they have until midnight of that day or the day before that day in 3 years' time to actually serve a summons on you in order for that claim to be valid. If they do, it interrupts prescription, and then the legal process runs its course. If they don't, then you have a plea of prescription which says you can't bring this claim anymore because you're outside of the time window. But for children or for anyone who is impaired in a way that for legal impairment, where you're not entitled to make certain decisions yourself, it's the time period runs until 1 year after the end of the impediment. And so being a minor is considered an impediment. You can't bring a matter in your own name until you are a major. And so at the moment, there are 18 plus 1 years if there is an injury or harm caused at birth, that child has 18 plus 1 years in order to institute action against you to interrupt prescription. I'm going to pause here just for a moment. There are a couple of questions. I thought maybe I could take those questions, or Karen, would you prefer if we just take the ones in writing at the end?
No, feel free. It's often nicer just to do it while it's coming up, so feel free.
Great, thank you. So Siva says, have you made use of Rule 41A regarding mediation before proceeding further? Although the plaintiff is not bound by it, it can save enormous amount of money and time and stress for the doctor. The answer is yes. We've seen mediations be very successful. Of course, it is a voluntary process, and if people aren't happy with the outcome, then they're still entitled to proceed in courts. We have seen quite a few plaintiffs when they serve the notice simply refusing mediation without really giving any good reason, and I suspect that a lot of those are because there's risk that their case is not very good, and they're not expecting good results with a mediation. But we're also, seeing results with mediation preceding a Rule 41, so before a summons is even brought, where there is voluntary pre-court mediation happening. Unfortunately, I have seen plaintiffs or patients at the moment really seeing mediation as a path to receiving an award that they would have gotten in court without having to follow the court process. And that's just not what mediation is for. And so those cases, the mediation is never going to be successful because the patient isn't coming to that with a genuine desire to meet somewhere in the middle or to resolve their complaint. They're coming with the desire to be compensated at a certain level. They're not really that willing to see too much reason. And that's always going to be a recipe for failure as a mediation. A question from Oscar: what is important is to let a patient sign an indemnity form whenever a patient requests you to send information, even completion of the format to any third party, including insurance medical aid companies. Absolutely, always a good idea to have an indemnity signed. We often will, where there's any doubt as to the other documents involved, we always whip up a quick indemnity that just says, you've given me authority to release these records. I'm going to release the records. I'm going to release them to the person you told me to release them to, and you agree to hold me harmless if any harm is caused by the fact that I've released these records. It's just a one-pager, but it's helpful to use. Raylene asks, are ultrasound pictures and laparoscopy pictures asked for by the patient? Is the patient entitled to those? Yes, if you have them on record, they are entitled to those. They do count as part of their own medical record. They have their own personal information on them because it's the results of medical scans, and so they are entitled to receive copies. However, you are not required to always provide this free of charge. If it costs you money to provide copies, or it takes effort in order to produce these, and it's not something that you've been subpoenaed for where it's going to court, you're also able to charge a reasonable amount of money to say, yes, I can give you a record in order to do this, because this kind of record, whenever there is some administrative cost involved, are you comfortable paying that in order to receive the records? And then lastly, can you offer compensation on humanitarian grounds? Absolutely. You can always agree to pay anyone anything, right? If that's what you'd like to do with your money. But there are consequences for doing so. One is if you do so without, if you're insured and you do that without the permission of your insurance or the authority of your insurance, then you will likely not be covered if that matter proceeds any further, or if the patient then brings a claim at a later stage. It can also be seen as an admission of guilt. And so if you ever do offer compensation like that, it's called almost like an ex gratia payment. You should ensure that the patient has signed a release and discharge agreement, which effectively says, the doctor has not admitted any liability for this whatsoever. I'm receiving a payment purely on, out of the goodness of their hearts. In return for this payment, I indemnify the practitioner against any claim by any person resulting out of these incidents for all time, just so that they can't turn around at some later stage and make a claim against you. But even if you're not concerned about that specific claim becoming an issue later, that is an event that could be considered, non-compliance with the terms of your insurance policy and end up with you not being covered for any claims and your contract for insurance being terminated if the insurer, sees that you are acting outside of the scope of the terms of your contract of insurance. So it's never advisable to do it without speaking to your practitioner, your insurers first.
Clayton, how does that tie in with just like a bill? patient maybe owes you some money. Maybe there's some outstanding, cash from a procedure or something.
It
Does
depends,
that
it depends on
include
your reason
that
for,
sort of
for
thing?
writing it off. So if you're doing it for accounting purposes, it's, over 120 days, you're never going to get it back. You're writing it off. That's totally fine. They're not going to come around and say, hey, you wrote this off, therefore you must have done something wrong. But if you are writing it off because something happened, there was a complication or anything like that, then that's when you need to really be more cautious. So if there's a reason other than accounting that you are writing off bills, then it's best to be certain. And if there's any reason that is related to the care provided or anything that could be considered to be negligence or even questioned as negligence, then it's advisable to have a release and discharge signed even for that.
Clayton, on that score of admitting liability, now, NatMed or any other, well, NatMed is not an insurer, I understand, it's a brokerage. But can an insurer say, listen, Dr. Snott, your problem is that you're having far too many claims against you. We're going to stop insuring you. Is that possible?
Absolutely. Yeah. If you become an uninsurable risk because of that risk of harm, then no premium in the world will ever account for the amount that you're going to cost an insurer, or in their view, they're going to cost, and they can choose to retract your insurance or withdraw your insurance, or to not renew. That's normally what happens, is that at the next renewal, they would not offer you renewal terms. It is possible that if really serious events happen during the course of a contract of insurance, that they can terminate that policy, but it would have to be written specifically into the contract of insurance. So it'll be in the terms.
Okay, thank you.
I realize we've run a little bit well, we're almost out of time. We've got still some time to have some questions. I'll just talk very briefly. We have, when you get each of these things, there's kind of what to do, right? We've got a series that we've produced called the What If series, and it relates to each of these. What if I receive a subpoena? What if I receive a summons? What if I receive a request for records? And it's just kind of what are the things that you need to be concerned about? What could you expect to happen next? These are free of charge. It's just education for everybody. So if you are interested, just let Karen know. We'll be happy to share some of those. And I think Karen will send a link in the next newsletter.
Yes. And of course, Clayton is very nicely, Clayton has very nicely offered his presentation as well. So if anyone would like a copy of it, you just send me an email and we'll send it back to you.
Thanks, Karen. I'll just talk very briefly about what we're seeing in trend or the trends in claims, some elements of this. So one is there's a lot of joint liability with hospitals being on the hook for things, or at least being brought in where they actually have done nothing wrong, just purely based on misunderstanding around the relationship between hospitals and doctors. And that has been persisting for the last easily 15 years. So I don't think anyone's going to clear that confusion up too soon. The value of claims is rising, but it's inflation based. It's not like massive leaps forward, but it's simply the fact that everything is more expensive. And so because everything is more expensive, the claims are more expensive, because claims are based on putting a person in the position, as close a position as they could possibly be to what they would have been in had they not suffered the harm. And so, if you consider somebody who has an amputation, they require a prosthesis. They need a second prosthesis in case that one breaks down. They should have one that is, robotic and top of the range. Then they should have a backup, and then they should have also that replaced every 5 years. Let's say they're going to live another 50 years. But once you calculate all of that and project forward for further inflation, you can see how inflation affects the overall value of those claims quite significantly. There's not really too much of an increase in frequency of claims. This seems to be relatively static over the years. There are very high claim values resulting from what we call international claims, which is where somebody, they give birth here, for instance, the baby is harmed. They move the whole family over to Sydney and then sue from there into a South African court, but are claiming in Australian dollars because that's the real consequence for them. That's their costs. And of course, something like that just shoots the value of claims up very significantly. We're all aware of, age and majority claims, nothing new, but something to constantly guard against. And if you do treat children, or if you are involved in births, it is always good to ensure that your insurance will still be there for you 21 years later, or at least 19 years later. So make sure that you're taking a policy that allows for you to still notify those claims up to at least 21 years. And then we've also seen the reopening of undersettled claims. So if your legal practitioners must ensure that they're properly settling matters, and that where something is being settled, that the amount is a rational amount. There's no benefit in going, hey, look what we got away with. This is 10% of what this claim should have been worth, but they're willing to accept it. The fools, because all you're really doing there is opening yourself up to the risk that in 10 years' time, out of the blue, someone's going to come along and say, hey, this was improperly settled. We need to open this case and start the whole thing again, and the claim will be brought to you at that point, which is obviously something we want to avoid. And take proper informed consent, and make sure that your informed consent, where it makes sense, is procedure specific, so specific to the main ones that you're doing. Beyond the ethical considerations and depriving the patient of the right to be involved in their own treatment decisions, this is something that leads to HPCSA complaints all the time, and to civil claims as well. Right? I've just received an email from a patient asking for 5 million rand. They're not going to get it. But because of a failure to take informed consent. So I didn't even know what procedures you were going to be doing on me, and I didn't consent to them. It's going to be a difficult one for them to prove, because I have the informed consent form with the procedure described on it and their signature. So I think we'll be okay with that one. But because we have that, we're going to be okay. If we don't have that, it becomes a much more difficult situation to deal with. So I think with that, we've got just a couple of minutes left. Let me just pop it over to questions. Maybe
Clayton, there's a question about.
We've got a few questions.
Yeah, there we go. It says, does age affect insurability? I guess that's age of the practitioner.
Yes, age affects insurability in a number of ways. So one, for an insurer, they need to ensure that you are going to be around long enough, or they're taking premiums long enough for to account for the risk that you represent based on the models that they have, the pricing models that they have, and all the factors that go into that. Age is always a factor that goes into it. If you are very near to retirement and you're doing 300 births, a year in your last year, an insurer, and you come to an insurer at that point to take insurance, they're not going to want to take you on, because there's, if something goes wrong, there's no way that they can ever recover the funds for that. But if you are, already a client, and you've been a client for 10 years, and it's your final year before you retire, and you're delivering 300 babies, that's fine, because you're still insurable. You have been insured. It's taking new insurance in that situation will be quite difficult. Also, if your age affects your ability to perform well as a practitioner. So if you're doing a ton of laparoscopic surgery and you're 106, an insurer is probably not going to want to insure you, because they can't. There's definite consequences for your ability to perform that with due skill.
And sorry, then Ali Marudu, what's the difference between practicing as a sole proprietor? Steve, you're just taking it away.
Sorry.
Practice as a sole proprietor and an incorporation. Is there any material change when you switch to the latter?
That is a good question. We please, if you don't mind, I've got my email address there up on the screen. If you just pop me an email and ask for it. We have just released our latest version of what we call our 4P pack. It's the Perfect Practitioner's Practice Pack. It has all of these questions in it, specifically the different types of practices, the pros and cons, and what the differences are. So everything in there will help you to answer that question. There's a whole host of other things in there as well that would just be beneficial. They're always good to review. Anyone is welcome to that if you'd like. My details are there up on the screen. So if you do want to ask any questions that we don't get to today, based on anything that we discussed today, I'm more than happy to take your questions at any point and to assist you.
And the last question, Clayton, and just before you wrap up, we've only got 1 more minute left. It's a question from an anonymous person who I recognize as Abib. I can see his signature. He says, what about mediation? Why has that not been instituted to a greater extent?
Well, the main reason that I think is because it's voluntary, right? So you can't force anyone to go to mediation. And so you have to convince people to go to mediation. And what we are doing is, the practice letters at the moment, we're also releasing a host of documentation, procedure-specific informed consents and practice documentation for everyone to use. But the practice letters that we're drafting do include in there at least a declaration from the patient that if something goes wrong, they will come to the practitioner first, and before going to the courts, that they will at least attend a pre-mediation meeting to hear what the mediation is about, how it works, and what the possible benefits are before they make a decision as to how they want to proceed. And so you can't force someone to enter into and abide by the results of a mediation because it's a voluntary process. But what you can do is at least put in that they do need to attend a meeting where they will hear about mediation and see what it could do for them, so they can make an informed decision about whether or not to use mediation. The more ubiquitous we can get the terms like that into all practice documentation all over the place, the more chance we have of really growing the use of mediation as a dispute resolution tool in these cases.
Thank you. Now, Steve?
Good idea, actually. Yeah, so no, but thanks so much. I think you raised a lot of important questions. A lot of us have maybe more questions than answers to some of the things, but you've certainly raised our sort of sensitivity to these issues, and I think really important. And we need to be more circumspect in terms of how we practice on a day-to-day basis, and looking for the potential of these issues all the time. So
yeah, thanks very much indeed, Clayton and Steve.
Yeah,
and a special thanks to NatMed, our sponsor. It's been wonderful to have you on board and assist. And we look forward to seeing Clayton in 2 weeks' time, Steve.
Yeah, great. Thanks so much. And then we can have some more questions.
And a final thanks to Corin. Thanks very much for your technical assistance, Corin.
No problem. If I can just mention that for the Stump the Professor Ask Me Anything session in 2 weeks' time, if anyone has any questions in the meantime, please pop us an email so that we can start to collate them and specify who you would like to ask the question to. And I feel, Clayton, you might be a popular one right now, as well as what the question is. That'll be great. And if you have any questions, just pop us an email.
Thank you.
Yeah, thanks so much.
Thanks so much.
Thank you very much.
And safe home. And we see you next week. And Steve, thanks for the use of your mini bar.
Any pleasure.